I'd like to call the Legislative Committee to order. We have just one item here, which is item number 5 for the cigarette and tobacco tax law and limitations on attorney's fees. So if we could have a staff presentation.
All right. Suggestion 5-4 was suggested by the legal department. It would conform all of the Board of Equalization special taxes, property tax, and franchise and income tax law to the sales and use tax law, limiting litigation costs, including attorney's fees.
Okay. We have two speakers, so if we could call them forth, Michelle Peel-Sticker and Leanne Tratton.
Madam Chair and members, Leanne Tratton, representing Consumer Attorneys of California. So it's not our typical forum, and I'm kind of pleased to be sitting here with Caltax, which is another unusual coalition. But we really are here for the same reason, and that is to argue for the small business owners that without the availability of these 1021.5 attorney's fees would have absolutely no access to justice. And you know, in these times where we are struggling to bring revenue into the state, we're certainly sympathetic to the needs of the Board of Equalization to, fight to collect these revenues. However, we always have to be cognizant of the rights of people who believe that the fees or taxes are illegally charged, and they have to have the ability to challenge that. The particular taxpayers in this case spent 9 years through the administrative process attempting to resolve their claim, and then had to ultimately go to court, where they did prevail, and at least one court has found that it was an illegally charged tax. These small business owners are not in the same position as many of the people who sit in the room today, I'm sure. Chevron and tobacco industry, other industries will have no problem challenging an illegal tax. But a small business owner is simply not in the position to, they're faced with a tax that they have to pay, and then on top of that, fight 9 years and then into court. And the standard for 1021.5, as has been stated by Caltax, is not a simple one to meet. It truly is only availed when a person challenging the tax is arguing in the public interest and could not otherwise argue because their financial means simply would not permit it. We really believe that it's important to keep this measure in place, which is very different from the existing $75, which in some ways is almost more like a punitive measure. 1021.5 is truly only enacted when there is a benefit to the public at large. And we would argue that, number one, this should never be operated retroactively to take away the ability of the people who have already been going through this process, but would also argue that it is not, in fairness, should not be eliminated as a proper means of giving small business owners the ability to challenge these taxes. For that reason, we urge your no vote.
Well, I'd like to say that I think this bill idea is especially important to present today, considering our state's out-of-control budget deficit and the fact that we are now facing the most unimaginable cuts ever in our state's history. And we, the BoE, we are responsible for bringing in $53 billion a year in revenue for the state.
Michelle Peel-Sticker, Caltax, once again. I just want to emphasize once again that this is not just conforming to sales tax and income tax. It's making this the exclusive remedy. And I also would like to restate that 1021.5 fees in tax cases are rare, mainly because it's such a high standard. And those are applied in situations only when you have a right affecting the public interest, and generally they're used when people normally would not find it economically justifiable to go forward. We're talking about holding the tax agencies accountable with regard to unconstitutional acts, and oftentimes those don't involve large amounts. And so while it may be reasonable to place a limitation with regard to substantial justification and a dollar amount, I don't think that it would be reasonable to make that the exclusive remedy.
Mr. Leonard.
I don't have any questions. I would speak in opposition to the proposal. First of all, retroactive law is just un-American. To change the rules of the game after the game is started or almost over is just wrong. Secondly, and maybe it's because I'm at the losing end of so many of our taxpayer cases, not that I want every losing taxpayer to sue the Board of Equalization, because reasonable minds do differ, but there are a number of those where I think another review of our decision would be in order, and this will just put a lid on that. It not only puts the threshold just beyond what anybody could allege or prove in court, but it puts an economic, it's $75 an hour is a joke. You guys are all laughing. None of our lawyers work for so little in our department, so it just strikes me.
Yes.
Yeah. Well, when they do, then maybe I'll change my mind. But we're not there yet. It just strikes me that what we're sending, the message we're sending, is the government's too big, too powerful, and we're always right. And even if we're wrong, we're not going to let anybody challenge us and debate that before an independent forum. And we're not sued. This department is not sued that often. And when the department is sued, we don't lose that often as a department. So it just strikes me that the rare number of cases where a judiciary says, you guys did do it wrong, that it's appropriate to pay the representative of that taxpayer a reasonable amount. And I trust the court and their expert system. They do it every day in civil lawsuits. In fact, if this law is such a great idea, why don't we apply it to all civil cases, all tort cases? It doesn't work. It does turn particularly unrepresented and poorer taxpayers who cannot afford upfront retainers away from getting redress and justice in this land. And for that reason, all those reasons, it's a bad idea.
You know, when remembering, as Mr. Leonard said, it's a very high standard to meet on this $75 an hour. It's nearly a frivolous standard, and courts rarely are going to impose fees in that circumstance. And we are not talking about having a bonanza here for the plaintiffs' bar. From what I understand, there have only been 2 of these cases brought before the BoE. And there are cases where people would never get here otherwise, and they will not get here under these changes. And I do believe that when we're looking at revenues, increasing revenues in the state, it's very important to give confidence to taxpayers that when there is an illegally charged tax, that they will have the ability to bring an action in the public interest and not have it bankrupt them. And I think when we're trying to protect the integrity of our tax system, it's very important to keep that power for the people who otherwise have no means to challenge it. So, thank you.
Okay.
I'd like to make a motion actually to amend the proposal, and which is to update the hourly rate to make it consistent with the franchise income tax provision in statute, and also to remove the retroactivity provision.
Okay. So there's been a motion for the bill proposal, but with the updating of the attorney's fees to be consistent with the Franchise Tax Board, and then also to remove the retroactivity. Okay. Is there a second?
A second.
Okay, then I shall call for the vote.
Ms. Yee?
Aye.
Mr. Leonard?
No.
Ms. Steele?
No.
Dr. Chu?
Aye.
Ms. Mendel?
Aye.
Motion carries.